to freedom of expression under the First Amendment. We'll take up general topics of the First Amendment, starting first with freedom of expression. Then we'll talk about freedom of religion and the Establishment Clause. Freedom of expression is highly valued in the society, and it's not surprising at all that the court has developed rather protective devices to ensure that we have a wide berth for freedom of expression. Even the so-called conservative members of the Supreme Court are very consistent in strong protections of free speech. The major dividing line that occurs in the doctrine, and where we'll start, is the so-called difference between content control and time, place, and manner controls. As a general rule, the government may not control the content of your expression, unless expression falls into one of a number of categories that we will discuss, where either the nature of the expression is such that it gets no First Amendment protection or maybe a lesser degree of protection. Categories, for example, like obscenity or commercial speech. Unless speech falls within one of those categories, pretty much the government may not control the content of what you say. And if it does, a very, very strict test applies to content or message control. It's the compelling justification test. The government would have to have a compelling reason for controlling that content. The law would have to be precisely tailored, and by that we mean the government would have to show that it had no less restrictive alternative ways to achieve its goal. It had to do it that way, and it's a very, very strict test. In fact, the court has called it exacting scrutiny, and very few content controls can survive that test. On the other hand, if the government regulation is not aimed at your message, not aimed at your viewpoint, not aimed at what you're trying to say, but instead affects only indirectly your expression as a kind of byproduct of regulating other conduct, then we apply a lesser test. For example, if the government is saying when you can march down the street, you can't march down during rush hour, whether you can use a bullhorn, let's say near hospitals or schools, then it's not aiming at the message, and a more lenient standard applies. As to those kinds of controls, time, place, and manner controls, the government can impose reasonable time, place, and manner controls. Now, in terms of reasonableness, what we mean by reasonableness is that, of course, it has to be content neutral. That's a requirement to have time, place, and manner. The government's regulation has to serve some significant government interest, and it has to be narrowly tailored. Now, this is not as vigorous, to be sure, as content control, which is a very exacting test, as I said, but it's also not a mere rational basis test either. There's a little bit of heft to this test. And in that sense, it's more than rational basis, but surely it's not like content control. So one of the first things you're going to have to figure out, because there is this major dividing line between content control and time, place, and manner control, is what kind of controls or government regulations you have on your hands. We'll talk a bit more about this in a moment, but just to get us started, as an example, say you had a law that said that you couldn't carry around any signs that supported Miss Smith for president. That would be content control, because there the government is aiming at the particular message on your sign. On the other hand, if the government regulation said that you couldn't carry signs into theaters or into certain other areas, that would be a form of time, place, and manner control, because the government doesn't care what you say on your sign. They're just saying that there are some places where it's inappropriate to have signs. So you have to make this distinction in the First Amendment area. It's important. Now, if it is content control, the government will have an opportunity to regulate to a greater or less degree if it turns out that the speech falls into a category that either doesn't get full First Amendment protection or doesn't get any First Amendment protection. These categories are incitement to violence, fighting words, obscenity, commercial speech, and defamatory and libelous speech. And we'll look at the categories. So we'll look at content control, time, place, and manner controls, these special categories. We'll also look at some special doctrines that have special resonance in the First Amendment area, doctrines of overbreadth and vagueness and prior restraint. And finally, we're going to look at some special contexts where the court has developed entirely special rules, if you will, about how far the government can go in regulating speech. We'll discuss, for example, expression in non-public forums, the regulation of the electronic media, that is radio and TV, the speech of public employees, government employees on the job, and finally the speech of students in school. Now that's where we're headed, so let's go. Starting again with content control. Since content control generates this very, very stringent and exacting test, far more stringent than time, place, and manner, you have to know something about what makes for content control. Content controls can arise in a variety of different guises. For example, it's a form of content control to prohibit or punish someone because of that person's beliefs. Persons can't be compelled to believe what the government dictates. And, for example, the government couldn't punish you solely for your abstract beliefs. To illustrate, the court held that the fact that a person was a member of a racist group, and we're not talking about whether a person had a motive to commit a crime out of hatred, but just the mere fact that they were a member of a racist group, could not be used, the court said, as a basis to enhance that person's punishment. Sometimes the fact that you have content control will be fairly straightforward. Take the case of Simon & Schuster versus members of the New York State Crime Victims Board involving the so-called Son of Sam law. At issue there was a New York law that said that profits from any books written by criminals which described their crimes could be taken from them to reimburse victims of crimes. The court found this to be content control because the government was taking the profits, but only from books depending upon what was said in the books. If the book described the individual's involvement in a crime, then it applied. The court applied its strict scrutiny, its exacting scrutiny, the compelling justification test in that case because it was content control. And the court said, well, okay, maybe you have a compelling justification to compensate victims of crime, but the law was way too imprecise, way, way overbroad. It reached any books or expressions that were sold for money, that expressed the author's thoughts or recollections about any crime that he or she may have committed. And the court, to make its point about how broad this law was, included an entire list of kinds of books that could have been included under this law, from Thoreau's Civil Disobedience to books by Martin Luther King, and even the Confessions of St. Augustine. It was a really extensively applicable law. But the point for our purposes now is that to apply a vigorous test under the First Amendment, we have to see if we have content control, and in this case, there plainly was. Now, there are some other kinds of content control that might not be so obvious. For example, sometimes the government mandates expression in certain ways. And people have the right to speak, but they also have the right not to speak. And so, for example, the court found as a form of content control a law that said that motorists had to display messages on their license plates, which happened to be, for one person, a religiously objectionable or ideologically objectionable statement. In New Hampshire has this expression on its license plate, live free or die. Well, making a person as a condition of driving a car carry around a license that says that, the court said, was a form of content control. Requiring persons to stand for the national anthem or forcing students to salute the flag, these too are forms of content control. Requiring corporations to include messages about conservation or other environmental views with their billings that they send out to customers every month is content control. Requiring persons who distribute political literature to identify themselves, or even, the court has said, requiring newspapers to grant rights of reply to persons whom they've criticized in their news articles. All of these things are a form of mandating messages, and they're a form of content control. Other forms of content control include singling out the press or certain publications for special burdens, for example, a special tax or special regulations imposed on some publications but not others. That's a form of content control. Sometimes it's content control when the government prohibits you from acquiring information. The court has relied, for example, on the First Amendment to establish a right of the public to attend criminal trials. Now, one area that's particularly tricky is the so-called symbolic conduct cases.